Moving on to my full-time job, Mink Law does approve of this presentation, although my opinions might not reflect those of my employers. So my full-time job is I'm an attorney at Mink Law. We're a small but national practice that focuses in the area of online defamation and online content removal. Now, my area of focus is generally revenge porn and sextortion cases, but we're not getting into that fun tonight. I also deal with hate speech and defamation claims as well on social media. So this presentation, they made me say this is not meant to be legal advice. It is always best to call us at Mink Law and get a consultation so that attorney confidentiality attaches to anything that you say, and we can collect our fee. Okay, so let's get started. So now when I first got this offer from Mink, I was afraid that I was selling myself short as an advocate, right? I was always involved in women's rights, domestic violence activism, and we've all heard the story about how defamation law is often used by abusers to silence their victims. Amber Heard, Johnny Depp case coming to mind. But since working at Mink, I've learned that this field of law, defamation law, is, in my opinion, largely content neutral, right? It can be used to advance my rights as a queer woman as well, and it can be used as a tool to combat hate speech. So if we can go to the next slide, if we haven't already.
We're on digital hate speech.
Great. So as we're aware, is this the one with the Twitter statistics? Yeah, that's the one I want to. Thank you. So as we're aware throughout social media, LGBTQ plus people and our supporters are being denounced as sexual predators, groomers, and worse. I've included some of my repeat offenders on this list that I have regular dealings with. Elon Musk receives reports on these accounts on a daily basis from me and my team. Now, what usually happens, and there was this one study by Institute for Strategic Dialogue on libs of TikTok in particular. They're one of the largest sources of online drag or online anti-drag hate that's on Twitter, right? So this includes anything from bashing on Drag Queen Story Hour to Drag Bingo, any drag event. So since working with libs of TikTok, or at least reporting them to X, I can confirm that this Institute for Strategic Dialogue study is largely true. So what happens is that my client is usually filmed or photographed, or maybe they're very excitingly interviewed by the news media. They're usually profiled as being LGBTQ+, an ally, or are out and proud. Now what happens is that this video gets posted on X or Instagram, Facebook, whatever social media platform of their choice. Users will then post a commentary such as this person is a groomer, they're grooming children, they're a sexual predator, or they pose a threat to, let's be honest, white cisgender heterosexual women. So, right, you have this narrative that's circulating, right? This person in the video, they're posing a threat to your white daughter, they're posing a threat to your children. It's generally a false narrative or something that's taken out of context. So what do you do when you have thousands of followers on social media? You're going to have thousands of people trying to find out who this person is. My clients' names are found, where their work is found. If you're real lucky, you can even find a personal address and a phone number. So now you have thousands of people that are crazy enough to call my clients either at their home or place of work, repeating these false allegations or promulgating a distorted narrative. Institute for Strategic Dialogue has also commented on how this affects businesses, particularly businesses that are supportive of drag performers. So what we see is, I can verify too with volunteering with Angels in Action that you have a narrative that a business is supporting child sexual abuse because they are hosting Drag Story Hour, right? This gets circulated on X, Facebook, Instagram. And then you have the neo-Nazis and Proud Boys showing up outside as parents are trying to walk their kids into an event. And maybe some idiot even calls in a bomb threat to protect the children, #SaveTheChildren. And as you can see from the slides, these platforms are profiting from hate speech. So they have no incentive to respond to my reports. And because in a lot of these cases, right, doxing isn't explicitly covered under state law. And if I send a cease and desist to a libs of TikTok user, do you think they're going to respond? They're going to accuse me of my client of being a snowflake. So again, it's very hard to get something that's been posted to X, to Meta, to any social media platform down when you have such high profits. But there are ways. So we know in the United States, we're an outlier in many democracies where we have almost an absolutist approach on free speech, right? Other democracies do sort of a balancing act where there's other rights that come into play when we're talking about speech rights. There are some exceptions to the free speech doctrine that I've listed on the slide. Next slide. The one that I'm most familiar with, though, is defamation. Now, hate speech in the United States is not a cause of action, right? You can be as hateful as you want, but there are ways to frame a hate speech case, in my opinion, as a defamation case. So I'll walk you through with one of my favorite false accusations that I see on lips of TikTok, which is that LGBTQ supporters, and those of us who are out and proud, are groomers, right? So I've listed the elements of what I need to prove as an attorney to establish a case for defamation. So first of all, it has to be a statement of fact. So the question that is intriguing about grooming is accusing someone of being a groomer, of grooming children, is that defamatory? Or is it an opinion, right? If I call someone a groomer, and again, the gaming community also has this issue where everyone's a groomer and a pedophile in the gaming community. At least those are the accusations hurled, right? A lot of times we're seeing that word used to describe someone as being kind of a creep, kind of a perv. Now, if I go up to Jen or anyone here and call them a creep or a perv, we're going to agree that's probably an opinion, right? A wrong opinion, but an opinion nevertheless. So what becomes hard for me is how do I take an accusation of grooming and argue to my judge that this is a factual statement, it can be verified. We can answer yes or no that so-and-so is a groomer. When it comes to LGBTQ rights, I think the analysis changes, right? We as a community have this history of anti-LGBTQ opponents, of homophobes, saying that we pose a threat to children because we love differently and we dress differently. It was used in 70s, 80s, 90s as an excuse to ban gay teachers from teaching in public classrooms. It's one that continues to resurface. So I think given this historical context, this almost Victorian mindset that those of us who love differently, that present differently, are deviant and are predators to children should influence how we view an accusation of grooming, right? Something is a fact if you perceive it to be a fact versus an opinion. I think I can honestly make the argument, it's not an allegation I would run into court. We'd have a very lengthy conversation before you spend thousands in court costs and attorney's fees. But given the historical context of LGBTQ folks being denounced as sexual predators, I think there is a case to be made that an accusation of grooming against a person who is known to be LGBTQ+ or a supporter constitutes a factual statement. Again, the analysis becomes easier if you just have a blatant statement of so-and-so is harming children or so-and-so is sexually abusing children. If it's false, obviously a factual statement can give rise to a claim for defamation. Second element, it of course has to be false. Truth, substantial truth, right? I mean, you don't have a claim for defamation if it isn't false. Statement has to have a defamatory meaning it's one that's harmful to somebody's reputation. I don't think anyone here is going to argue that being called a groomer is not injurious to someone's reputation, even if we do consider it to be opinion. The accusation also has to be against an identified person, right? So remember, hate speech is not actionable in the United States. A general statement by someone on X that all LGBTQ people are groomers, our supporters are groomers, right? Anyone who supports a specific legislation is a groomer or is sexually harming children, not actionable, right? The court has to know who's being injured. Defamation is a personal tort. And in the United States, right, businesses and organizations are people that can bring suit for defamation and trade libel as well. If it's clear that someone is being singled out with these accusations, you've met that element that you have, an identified person who's being defamed. 5 is that the statement, it has to be published, right? Someone sends you a text and calls you a groomer, accuses you of sexually abusing children. You can't bring a claim for defamation, right? Defamation is harm to your reputation. Even if you publish that hateful text on your Facebook page, X page, right, you're doing the harm to yourself. It's not published. The court's going to look at you like you have 3 heads if you file that claim, right? It has to be published by the defendant or spoken by the defendant in order to be actionable. Defendant also has to act with the requisite degree of fault. So average people, like everyone sitting here today, with maybe a few exceptions, right? You're a private individual, right? You have to show that the defendant acted negligently, meaning that they knew or should have known that the statements they were making against you were false. Now, if you're an elected official, a celebrity, you're a public figure in any capacity, you have to prove actual malice as a plaintiff, right? That someone either knew the statement they were making was false or was just so reckless when they uttered that statement that it gives rise to liability. And finally, we have to show that the publication, that the defamatory statement caused injury. Monetary harm, right? If you are losing job opportunities, losing business because of this statement that was made, that's going to be proof of injury. Now, certain allegations, such as child sexual abuse, are just considered so egregious that I don't need to prove that you were injured, right? This is defamation per se. The court's going to presume injury in cases of defamation per se. So hopefully you never need us at Mink Law, but we're here if you're being defamed, bullied, doxxed, have certain pictures you don't want up on the internet, posted online. We are here to help. Hopefully you never need to give me a call, but if you do, my contact information's on the board. We also make amazing TikToks. I'll be starring in one next week that involves a case of alien abductions and defamation claims, so please follow us. Thank you.
Can you speak just a little bit about the drawing the line between free speech and protected and unprotected speech when it's in an organization and it defies the values of the organization? A little bit about that.
Right, so as long as the organization's not a public entity, you can sign a non-disclosure agreement with any employer. I can't remember what they put in my contract, but you sign certain things when you sign up for an organization. An organization that's private can regulate your speech. When I'm drafting non-disclosure agreements, right, those are two private individuals that are agreeing not to say certain things. It's very different if I were to go to a court, right, and get a court order. The court's not going to put a gag order in because that would be a government act. But First Amendment only applies to government action.
Right.
Private individuals, private entities can choose to reflect those values, but they don't have to. You can be fired for what you say at work. Yes.
I will just add, because I'm a labor lawyer, that there are limits, though. There's no law that says your employer can't fire you for sharing political opinions. There's no federal law. There are some states that protect political opinion statements. But for people who are non-managers, such statements may be covered by the National Labor Relations Act as protected concerted activity. So if you're expressing support for a particular political action because it will make you feel safer in your workplace, or because it will be better for you financially as a worker, you will see protection for yourself and your coworkers as workers, then that is protected under the National Labor Relations Act, and it would be an unlawful firing and would be actionable with the National Labor Relations Board.
Yes.
Do you think with this hate speech, and if you could prove a defamation action, is it defamation or libel per se, or are they all per quote cases?
That's I think the grooming accusations would be libel per quote, right? I have to show that the grooming accusation is being, understood to mean that you're harming children, right? I would look to the context of which the statement is made. If someone's, suffering any sort of harm, that would be evidence for me to show that this, statement is being accusation of grooming is being understood to mean that person is harming children and is having a negative impact on their reputation. But if it's just a blatant allegation, and I've seen them too, where so-and-so, showed their, I'm just making things up here, but so-and-so showed a child pornography, right? Or so-and-so sexually harmed a child or exposed a child to something that was inappropriate. That's going to be defamation per se if it's false, at least in the state of Ohio. Thank you.